Hello, Colorado Realtors. Thank you for joining us for another edition of Legal Bites. I'm Scott Peterson. So today on Legal Bites, we're going to be talking about a topic that I think creates a lot of potential peril for realtors and buyers and sellers in a contract, for everybody involved, candidly. It's the lead-based paint disclosure and the timing on delivery of the lead-based paint disclosure. Really important topic here. So first of all, the lead-based paint disclosure in and of itself is driven by federal law. It's an environmental protection agency who mandates that federally for every state in the country. It's mandated. In Colorado, we have memorialized the delivery of the disclosure and the mandate for the delivery of disclosure in paragraph 10.10 of the contract to buy and sell. You all use it every day, but don't necessarily pay attention to it in a manner that I think parties need to be. It's very punitive if the specific provisions of paragraph 10.10 aren't adhered to, or I should say potentially punitive. So I won't read the entire provision to you, and you may not be able to read it up there, but I would encourage you to, all of you, next time you're in your contract system, software systems, or looking at a hard document, to really read and understand paragraph 10.10. The gist of what it says is that for any home for which a building permit was issued prior to January 1st, 1978, which in the Denver area and throughout Colorado, really, we're an old state, and we've got a lot of homes that were built where building permits were issued prior to that date. So it definitely applies here substantially in a lot of cases. Not for new construction. Anything that was permitted after January 1st, 1978, no lead-based paint disclosure is required. But in the event that a home was, then two things have to happen. One is the lead-based paint disclosure needs to be signed by all parties, and that's buyer and seller, also not parties to the contract, but needs to be signed as they are involved in the transaction, needs to be signed by the brokers, by the realtors in the contract. So buyer, seller, and realtors need to sign the lead-based paint disclosure, and that needs to be delivered back to the seller prior to the execution of the primary contract. In the event that that doesn't occur, it says right there in the paragraph, 10.10, that the contract is void. It's not voidable, it is void. The contract doesn't exist. Okay, so that's pretty darn important if parties are delivering the lead-based paint disclosure, as an example, even just minutes after a contract is signed. That contract is technically void. Now, I think this is even more particularly important since the advent of contract software and digital signatures, whereby we can see the exact date and timestamps for every document that's executed. And so in the event that a lead-based paint disclosure is signed by one or more parties after the primary contract is signed, then that contract in and of itself, again, is void. It doesn't exist. So it is not uncommon that that occurs. I think sometimes your clients get a little bit confused. Maybe they sign the lead-based paint disclosure after. They're more focused, of course, generally at that time on the contract itself, not paying so much attention to some of the more peripheral disclosures. But this is the one that is really, really important, that it is delivered in a timely fashion. So make sure that your clients are executing, and that both realtors or brokers are executing the lead-based paint disclosure prior to the party's execution of the contract. In the event that something were to come up, somebody wanted out of the contract, it goes directly to the enforceability of a contract. Again, per the terms of 10.10, that contract is void. Not voidable, it is void. It technically does not exist. So, real big pitfall for both for either a buyer or a seller, and certainly potentially no exposure for licensees, as you guys are allowing that to occur post execution of contract. So very, very important paragraph. Make sure that execution is timely. I can't say it enough. I hear all too often that it occurs after contract, and sometimes even as late as at the closing table, and that's just not acceptable for anybody to have parties performing on what is really a void contract throughout an entire due diligence period. So be careful of that. Pay attention. Hope this is helpful. As always, the Car Legal Hotline is available 9 to 12 and 1 to 4, Monday through Fridays. Thanks so much for your time and joining us today for this edition of Legal Bites.